afternoon. This is Mai Fernandez with National Center for Victims of Crime. Good morning to you from the West Coast. I guess good morning to you from the middle of the country, and good afternoon to the folks on the East Coast. It's a pleasure to be with you, and we are talking this afternoon about engaging victims in the criminal justice reform. And this webinar is by the National Center for Victims of Crime, but it's supported by the John D. and Catherine T. MacArthur Foundation through Safety and Justice Challenge. So just to tell you a little bit about what the Safety and Justice Challenge is looking to do is to stop over-incarceration in America and the misuse and overuse of jails around the country. It's meant by the foundation of $1 million over 5 years. The 34 counties and in 4 cities, for ways to reduce jail populations and address racial and ethnic disparities in ways that keep the community safe. The Network for Victims of Crime is one of the strategic allies involved in this movement, and we're really proud and happy that the MacArthur Foundation gave us a seat at the table. When we came to MacArthur, we said, you know, victims are at the moral center of the criminal justice system. Many offenders are also victims. So we said we'd really like to be part of the Safety and Justice Challenge so we can talk about these issues and really figure out how victims can be stakeholders in this movement. So what we've done over the past year, and for those of you listening, if anybody has questions, you have the capacity in the Q&A section of the webinar to ask questions, and I'm happy to stop and answer your question in the middle of whatever I'm talking about. Also be a survey at the end of the webinar that will ask you some questions that will be able to really move us forward in this work. So please engage in this webinar. I know sometimes it feels like a one-way street in these kinds of sessions, but please, as much as possible, ask questions or make comments or tell us what you think or don't think. What we did over the last year was we tried to engage with local victim advocates. We did that basically through 2 methods. We had roundtables and we had webinars. We had rounds in Pennsylvania, North Carolina, Washington State, South Carolina, and South Dakota. We also did webinars in Arizona and Missouri. These are all sites of the Safety and Justice Challenge. We took transcripts from each one of those roundtables and webinars, and we looked at the similarities. Every jurisdiction was facing different kinds of issues, but there's many similarities between the jurisdictions, and many of the victim advocates that we brought together have brought up the same types of issues. So what we had to do was boil down the essential principles of what the advocates told us would be needed for to feel as true stakeholders in the Safety and Justice Challenge. And we brought those down to 8 guiding principles. Our hope is that these principles will help criminal justice professionals better understand how victims experience the criminal justice process and what front-end reforms are necessary for them to feel represented and heard. And sometimes we use that term front-end reform. That really means how it needs to be, how victims need to be involved in reforming jail. So one of the reasons that we are having this webinar today is not just to tell you what we've done, but we need your help. We want to ensure that these principles are accurate and representative of your experiences and are aligned with your ideas for reform. The voices will help us elevate the voices of the community you serve. We want to contribute to a meaningful change in the criminal justice system. So we'd like you, through the webinar, to share your thoughts. We're going to be providing a survey at the end of the webinar. If you'd like, you can also email us at bmacarthur@ncvc.org. And we will send you this information after the webinar, so don't worry about having to scribble this down right now. So we've created these principles and done tables and tried to get information from victim advocates. What are the next steps? We will emphasize the feedback from this webinar and other events where we're presenting this information. So we want to take what we've already done and make it stronger and better. These principles to the state justice sites around the country. And we want to provide ongoing support and technical assistance to safety and justice sites through our role as a strategic ally and help them implement these principles into their criminal justice reform. So we're going to go through the principles, and please, like I said, if there are questions, stop me and I'll answer them as we go along, or if you want to wait till the end, you can ask your questions then. Number one, we want to recognize and inform victims' rights. States have enshrined victims' rights into their constitutions. Every state has victims' rights of laws. You know, a lot of times victims' rights are not enforced. If we're reforming the justice system, we have to look at ways that we can enforce victims' rights on a much more even-keeled basis, and not on such an ad hoc basis. And thinking about reforms, we have to think about how do these work with victims' rights? Or we make sure that in no way, shape, or form the reform is affecting one of these rights. I know some of you know those basic rights are, but just for the sake of going over them, it's the reasonable protection from the accused, notification of any public proceeding, and confer with a government attorney, and be it with fairness, dignity, and respect. Those seem like easy things that we should be enforcing on a regular basis, but so often they're overlooked. That's principle number one. Principle number two is the prioritization of victim safety. When offenders are released into the community, the criminal justice system needs to ensure that victims are appropriately protected, connect them about the type of protection they need, have mechanisms to put those protections into place. These are adequate notice to the victim of the offender's release, provision civil or criminal orders of protection, safe exchange of visitation of children. Three, and who have worked with victims for a long time know this, that sometimes we like to create a bright line between who's an offender and who's a victim. In reality, there are many offenders who are victims and many victims who are offenders. So what we need to do is break down that false dichotomy. We need to stop barriers that have been created in order to figure out what's the underlying trauma of an offender. Is because of a form of victimization, and being able to address that properly through counseling and various types of services. There also needs to be access to rehabilitation. Access to trauma-informed victim services need to be provided to offenders. Principle 4, affordable and effective and high-quality victim services. Sometimes I talk to those who are working on criminal justice reform on the offender side say, well, don't victims always get services? And it's a surprise to them when I say no. So one of the principles is ensuring that we provide sufficient and affordable services for victims to feel safe and to rebuild their lives. True justice and reform must focus as much on victim services as it does on offender services. Principle 5, affordable, and effective, and high-quality offender services. So let's talk about diversion programs. Oftentimes when we talk about criminal justice reform about offenders, we talk about diversion programs. Treatment centers, mental health programs, specialty courts, housing, jobs, trauma counseling, early intervention programs, batterers intervention programs. With availability and accessibility and sufficiency of these kinds of services, diversion programs could place victims in fear of their personal safety. So what we heard throughout our roundtables was we want there to be good services for offenders, but we want to make sure that they work, that there are sufficient numbers of them. Is adequate supervision of offenders in community programs. Adequate supervision of offenders if they're diverted to a community-based program. Accountability. Hold us accountable for violations of the program, compliance with the program, or failing to complete the program. Lack of accountability in out-of-jail-based services causes victims to distrust and not want to engage with the criminal justice system. So, for the part, when we were at our roundtables, the victim advocates said we were in favor of strong programs, out-of-jail programs for offenders, but we want to make sure that there is accountability and an offender doesn't go or doesn't finish the program, that they'll be held accountable for that and there'll be clear consequences. The simple, accessible, and trauma-informed criminal justice professionals. Many advocates that are out there know that there are counselors out there, but there are insufficient amounts of counselors that are really trauma-informed. One of that we've done, that the National Center has done in the last few months, is work with the victims of Las Vegas shooting. One of the things that we saw there was that there was many counselors that wanted to come and help those victims, but very few of them were trauma-informed. And really was a problem in providing good services to these victims, and also is a problem for providing good services to offenders. So, informed trainings help explain victims' behavior, facilitates access to victim services, and factors victim cooperation and promotes trust. We all want to make sure that the procedures that are out there are fair to victims. That's what we often call in the field procedural justice. The victim to feel satisfied with the outcome process, but they need to feel that the process was fair, that they were able to be part of that process and were treated fairly and with dignity. Is one where it came up in many different kinds of ways, which was when there is a relationship between the offender or the victim, and that could be between intimate partners, it could be an intrafamiliar, it could be a caregiver, it could be people who work together, it could be people who live in the same neighborhood. You pay a lot of special attention, because generally those are where issues can come up between offenders and victims. one party's controlling the finances. Also have the special needs of the children or how visitation is going to be dealt with. If a caregiver is found to be the offender, how is the victim going to continue to receive services and make sure that they are still well? I think a lot of our advocates at roundtables and at the webinars talked about interdisciplinary teams, bringing special teams together to work with victims and offenders, medical, social services, workplace, community, and service actors coming together to figure out how best to serve a case so that another crime doesn't take place. Came out quite often was pretrial assessments. Of the Safety and Justice Challenge, we're using pretrial assessments in jail. And the jail were very much in favor of these assessments, but felt that when there was an intimate party case, these assessments really didn't look thoroughly at victims' issues, particularly around safety. So how do those pre-trial assessments really take into consideration when there's an ongoing relationship between the victim and the perpetrator? So, couple questions. Is there the information obtained from roundtables in the Washington State specifically, and who participated? And the answer is absolutely. We can we'll check in Washington State that we did our roundtable in Spokane, and I will reach out to the folks out in Spokane and see if the actual minutes from the roundtables could be released. But we need to check into that before we put that up publicly. Next question, can you clarify who is an offender? Does this term include accused people who are being held in jail pre-trial? Absolutely. This term does include people who are being held in jail pre-trial. Many of you may know that VOCA dollars can now be used to help others that are in the jail system. Many of the Safety and Justice Challenge sites are particularly focusing on female offenders who are in jail, many of which have been victimized either through domestic violence or sexual abuse. So very much are we looking at offenders who are currently in jail pre-trial. Question. In regards to principle number 1, how do we enforce victims' rights when they do, in regards to principle number 1, how do we enforce victims' rights when they do not have standing in the court? Did victims advocates, victim advocates any recommendations to balance victims' rights with offenders, such to eliminate any obligations? I think I understand the question. So a lot of times we hear about situations in courts where victims were not allowed to speak, where advocates were not allowed to speak. Those are often as having an advocate there to be able to speak on their behalf. I've heard is the ability for a victim to have an advocate during a court proceeding so that they understand what's going on and have notice of what's going on and how they can participate is the key to balancing those rights. If an advocate can speak in a courtroom on behalf of the victim and be sure that those rights are protected, and in cases have a lawyer to stand up for those rights, that's how you get the best balance in a courtroom between offenders and victims' rights, and to make sure that victims' rights are upheld. One of circumstances, case types for which incarceration may actually be the most appropriate option, such as homicides, crime, sex offending, etc. So one of the things I want to make clear is that we're talking about jail populations. So jails are where offenders are being held pre-trial. This injustice challenge is really looking at those cases not like homicide or a serious sex offense. It's lower level crimes that somebody who's killed somebody shouldn't be served in the community. And I think what we're looking at is lower level crimes and people serving time in jail that could be easily served in the community if the right kinds of programs are put in place and the oversight is put in place. Questions that we have right now. Are there other questions that people have? Are particular principles that you have questions about? I think that we've missed other things that would bring victim advocates as stakeholders to the safety and justice movement. We are really looking for victims to become stakeholders in this movement and be able to say, I agree with these kinds of reforms and these kinds of reforms that I do want to see in my community. If these kinds of principles are embedded in the reforms. So if there are things that we've missed, if there is information that we just didn't get from the advocates that we talked to, we really want to hear from you. This is a document that is evolving, that we want to make stronger, and we want victims to feel like they're really part of the criminal justice reform movement. And so anything that you think that could bring you, advocate, to the table, please message us either now during the webinar or in the search afterwards, or please feel free to email us. We hear from you. If there's more information that you would like to present to you, would like more information on the kinds of reforms that are going on in jurisdictions across the safety and justice challenge, we'd be happy to present that to you also. Another question. Prosecutor, and I agree with these principles, but we find our judges don't consider victim safety or history of failure to appear when released. Sorry, we had a blip. So again, I'm a prosecutor and agree with these principles, but we found that our judges don't consider victim safety or history of failure to appear when they release particularly everyone on own cognizance as their judicial input on these principles. We had judges, I think, at every single one of our roundtables, but on level, they were pretty self-selected judges, so judges that were more interested in upholding victims' rights and upholding victim principles. We did stories about judges not really all that concerned about victims' rights or the history of an offender. So stories did come up, and I think that the judges that did appear were very concerned about how we could balance reforms for offender with victims' rights. This is a good one. If you could, if you have ideas of how we could try to bring these principles And if there are forums that we could engage judges on these conversations, I'd be happy to reach out to them and would really appreciate your input, because I think your question is one that comes up a lot and that we need to look at and figure out. Okay, and, what are the best ways victims can recover restitution if the defendant has not paid? I'll tell you, I don't necessarily have a clear answer to that, but I will get my staff to look into some best practices in that, and we can email. If you email us, we will try to email you back some best practices around that issue. Groups in Hawaii, and a main concern was providing clear information about the criminal justice system pre- and post-conviction. What does concern fit in the 8 principles? So I'm not sure if the person who has provided this question, when you say main concern was providing clear information about the criminal justice system pre- and post-conviction, was that about how the criminal justice system in a particular jurisdiction in Hawaii and how post-conviction processes work and how that can be made clear to victims and how they can get access to that? I'm trying to see if this is your question. Again, I think that the best ways that we have seen victims have access to that kind of information is to have an advocate and or a victim attorney. But you can, if you elaborate on that question and I have not answered that correctly, I'm happy to get more input from you. So then there has been some interesting pushback from the defense bar regarding victim is a victim. They believe that they only become a victim upon conviction. A former prosecutor, and we call victims, we call them complaining witnesses because of that exact issue. I think that in the criminal justice system, judges in particular don't want to call somebody an offender or a victim because a case hasn't transpired yet. And sometimes there's problems in a case setting with those labels. That doesn't mean that a victim can't access rights and doesn't have rights prior to the case being concluded. So that we have mentioned under Principle 1, here to what somebody might call a complaining witness. So just because a victim isn't being called a victim in a certain set of circumstances doesn't mean that person doesn't have those rights. Regarding victims' rights, despite victims having no standing in a criminal case, some states like Colorado and Wisconsin have victim rights compliance process incorporated into their victims' rights laws. Yeah, absolutely. In some states, like I said, the victims' rights are enshrined into the Constitution, and some states are much better at ensuring that the victims' rights are put forward during a criminal case. Now, it seems like most pretrial reform sites are measuring release rates, appearance rates, pretrial rearrest rates. Shouldn't these systems also take some measures of victim safety, protect orders, violations, and enforcement? I think it would be phenomenal data to be collected by sites. I think it would balance everything that we're doing in sites. I think the more data that we have about how our criminal justice system is working on both sides is something that we need. So I do agree that that would be a very good thing to do across the country. Using validated risk assessment tools and processes to inform discussion about who to release pre-trial and with conditions in place. This has come up quite a bit around the domestic violence situations. There are actions that use really two assessments. They use regular pre-trial assessment, but then they'll have one if it's an intimate partner situation. Some jurisdictions call it a trailer assessment to figure out what special conditions need to be put in place because there is a relation between the offender and the victim. I do something that needs more research because we need to figure out which is trailer assessments works best. Should it best practice that every jurisdiction that has a pretrial assessment also have some sort of intimate partner assessment? These are research questions that we are talking with other of our allies with and trying to see how we could come up, really look into these issues and come up with some well-informed answers. So I do think that's a really question and one that we are looking into. Was there discussion at your roundtables about alternative forms of justice, including restorative justice and that are victim-centered and trauma-informed? Yes. There's a lot of discussion in many shapes and forms. People did bring these alternatives up. It often comes up if there's a crime in a school-based setting with a juvenile. In Safety and Justice Challenge, we're not really looking at juvenile populations. However, they did come up. The alternatives were looked at as possibilities, things that we should be looking into. I think that one of the issues that was also flagged was to take these alternatives to scale. A lot of jurisdictions have them, but how do you scale them, and how do you get them prepared to enter into one of these alternatives? Because we know these alternatives only work if both the offender and the victim want to proceed in that direction. Those were the types of discussions that we had around these. Most crimes do not result in arrest and conviction. It seems like there should be some principles of good policy related to how to support victims even when a perpetrator is never caught. Further with that, most crimes are never reported, so we need to have victim services in place to deal with victims that may not be ready to into the criminal justice system or do not want to go to the police. It's something that we talk about a lot at the National Center for Victim Crime. It has to be prepared to enter into a criminal justice process. And if they're not ready yet, how do you access services and how do you make sure that a victim can still be whole outside of a criminal justice process? Do you have information on preferred practices related to pretrial personnel contacting victims to gather information for bail decisions? Of information, one of the sites that we did go to visit, it was Bonton County, it was Asheville, North Carolina. They have an innovation that they're doing with the MacArthur funds that they received. They hired 2 part-time pre-trial personnel whose job was to really see how by contacting both the victim and the offender, could, in domestic violence cases, they could reduce the probability of contact and therefore reduce the possibility that there could be another altercation between the parties. So it is something one of the sites is looking at, and I think that that site is ripe for more research in that area. When this question says, please ignore this if it's already been answered. I had to join late. Can you speak to the inclusion or not of domestic violence and sexual assault risk and safety concerns in more general pre-trial risk assessment and tools versus focus on risk of mid-court appearances? That's been answered, and again, I think this is an area that's ripe for research, because what we heard is that many jurisdictions do have these pre-trial assessments for domestic violence or sexual abuse, mostly domestic violence. We didn't really hear about that many in the sexual abuse cases. And I think that we need to find out what the assessments are, when they should be used, if they should be used consistently when there's a relationship between the two parties. And it's an area that we're looking to do more research in, and it came up in just about every one of our roundtables. Have information on pretrial personnel requiring victims to personally present and sign paperwork indicating they would like another release. Have any particular information on that? I have not heard about situations like that didn't come out of one of our roundtables, but if during the survey or through an email you could provide me with more information on that, we'd really like to know about that. Next, do you anticipate further study on input for high-level crimes? I think this would be valuable. I think that that question for the safety and justice challenge, I think right now we're looking at lower level crimes, but it could be that it has come up for us in other settings, not through the safety and justice challenge, but through other programs that National Center is working with. So I know that there are other organizations that are working on those issues. I don't know if the safety and justice challenge is looking at the issues. What is not, this is the next question, I'm sorry. What if there are not adequately trained volunteers who are willing to work with the NCVC? How would or could it be set up in their state? Question is if you're interested in figuring out if justice reforms are taking place in your state, or if your state or jurisdiction is not involved in the safety and justice reform, where are taking place in your jurisdiction, and how could you get involved? Or if there is insufficient volunteers, how do you have a victim's voice forward? I think what would be good is if you would email us your particular situation, and we could do a little research as to jurisdiction wants some reforms, and then maybe we could suggest ways for a victim voice to be heard regarding those reforms. Do you have information for how to facilitate victims' rights when neither victims nor victim advocates are given notice or the opportunity to attend court-related to bail or EPO decisions? Quite frankly, I think we can give you more information on this, but this is a good question for us to pass on to one of our victim partners that deals with victims' rights specifically. And now, in a situation like that, a victim could have a voice. So if you email us or put that into the survey, we can get back to you on more specific ways that a victim could be upheld in those situations. What are those jurisdictions, and where can we find that trailer assessment as relates to domestic violence and sexual assault? We have the same concern. It is not considered well in our pretrial release program. We can provide that information to you in an email after this webinar. That would be something that we could provide to you and give you the information that exists. Practices for ensuring that victims have an easy way to express safety concerns during pretrial period. Go back to an advocate, and so when an is made, the best thing is to ask a police officer at that time, you know, I would like to see a victim advocate. In some situations, police officers do on the spot, and that is how somebody receives a victim advocate. But these or the prosecutor's office should be able to provide you with a level of advocacy so that your rights are protected. If you could just hold on. Leaded down from felonies to misdemeanors, frustrating to victim and advocates, and limits victims' rights in courts. Any discussion of how to handle this issue and offend accountability programs for offenders when charges are reduced. We did a discussion about this at our roundtables, but it is something that we could reach out to one of our partners and find out if there's some best practices around. Hold on, we're getting to the next question. I have Principle 8, and creation of other types of relationships as well as infant, partner, and sexual assault. Was the need for additional training for PUs/judges and advocates discussed for those other types of relationships? The gap in knowledge and services. There was no particular training that came up for judges, but I think that is a very good suggestion that we should look into. With the various state victim assistance academies, SVAAs. What happens to be that the National Center for Victims of Crime, the state victim academies, for those of you who don't know, are academies in a large number of states. Not every state has one, where new advocates and older advocates can go to learn they have Vic 101 through, seriously experienced victims. As to where victim advocates can go and learn and keep up their learning. We provide training and technical assistance to the state victim academies across the country. Bring this up to our program directors and say that this would be a very good thing, that we have the specific topic through the SVAAs. I think that's a really good suggestion. Most of the questions that have come up, if who are on this, again, have further questions, we will try to get back to all those questions that we didn't have answers to you in the next week or so. If other ideas or suggestions come up, or the feeling that we need a second webinar of some sort that need more information, and this was a good preliminary introduction, but not enough, please give information on what more you'd like to see. It's been a pleasure and honor to provide this information, and our hope is to continue to make victims' voice heard in all criminal justice reform. I also want to thank the MacArthur Foundation for their bravery to go into this topic. A lot of funders there don't understand why victims should be involved in criminal justice reform. The MacArthur Foundation gave a seat at the table, and that was a really amazing step. Because, as we know, the criminal justice system has to work for both sides. The fact that they understood that and gave us opportunity is really amazing, and we hope to make the most of it, and we hope to include all your voices in our discussions with the MacArthur Foundation. Thank you very much.